And welcome back, everybody, to the Law News Network. I'm your host this afternoon, Rachel Stockman, and we were just watching testimony live in the Frank Bybee attempted murder trial that's happening right now in a Florida courtroom. It's been a very interesting case. We just had the victim, the alleged victim, Marcia Souls' doctor, her psychiatrist, on the stand talking about the time she attempted suicide, or at least threatened to commit suicide. This is a case of a former sheriff's deputy that is accused of trying to murder a 79-year-old woman who he happened to meet while he was out on the job responding to a situation involving her. He's accused of befriending her, getting entangled in her life, getting entangled in her finances. He's accused of trying and taking money from her and then trying to stuff pills down her throat and kill her. It's a really unbelievable story, and I'm joined now by my guest this afternoon, Mari Henderson, who's an attorney out in California. And you see, Mari, a lot of crazy cases in California too, but this one kind of takes the cake in terms of some of the details of this.
Yeah, this is one of the more bizarre trials that I've seen, just because of the defendant's background, the victim's background, and the relationship between the two.
So what do you make of the, I think you were listening a little bit to it this morning, but if you didn't get to catch it, there was kind of a bombshell moment that happened this morning. And that's when one of the experts that the prosecution called, who is an expert, like a forensic expert of computers, talked about how he traced an email that was sent from the victim to her doctor threatening to kill herself. And I believe we have a picture. Kathy, our senior producer, captured a screen grab of the message that was sent. I think we can bring that up hopefully soon. But it basically said that she was suicidal, she was going to kill herself, there were some expletives. And this forensic scientist, computer expert, traced it back to the IP address of the defendant, Frank Bybee, and said that it actually wasn't her that sent it, that he was what's called spoofing her email and sent this to the doctor in order to try to get her committed under the Florida law, the Baker Act. What do you make of this testimony? That's pretty bombshell when you have the IP address traced back to the defendant in a case like this.
But again, you have to remember that on the stand, he did say that, yes, I can trace back the IP address, who sent it or where it was sent from, but I don't know who wrote it, so the defense could get up there and say, she wrote it from his house, or, some crazy explanation, which I'm sure they'll try to give because they'll have to. But I think it is pretty damning evidence against the defendant that he was really taking advantage of this elderly woman. And so, the charge of exploitation of an elderly victim is one of the 18 charges he's facing, and sending an email pretending to be her and trying to get her committed, that is the definition of exploitation.
Exactly, and again, I was just corrected that the doctor on the stand was actually her internal medical doctor, but regardless, he was very involved in her health and her mental health, and did testify to the fact, that she suffered from depression, that she did try to commit suicide before, or at least threatened to, and that's one of the defenses in this case, and that is the defense is trying to say, well, this woman is not all with it. We can't really take her word for what happened, and of course she took the stand testifying to what allegedly happened. So in a sense, the fact that her doctor said that doesn't really help the prosecution's case.
If she had only tried to kill herself after she met Frank Bybee and they could prove that he's the one who sent the email, then that helps the prosecution. But then if he said that she tried to kill herself even before she met him, then it's kind of a wash. You can play it both ways. The jury can read it as either, this was a woman who was taken advantage of, or this was a woman who had mental health problems, and even more if she identified that she was willing to self-inflict and hurt herself even before meeting him, then doing something like sticking pills down a throat and staging something wouldn't be, out of the realm of possibility.
Here's what's kind of interesting. The doctor testified to the fact that when she threatened suicide before, that it was going to be via carbon monoxide. When Frank Bybee, the deputy, allegedly did this, okay, if we believe the prosecution's theory, he not only tried to stuff pills down her throat, but he also left the door open to the kitchen where she was and allowed the fumes from her car to go into the house. So it's kind of interesting here that you have the doctor testifying that this was a way that she had kind of talked about killing herself, and then you have evidence that this is kind of what ended up happening. What do you make of that?
Sometimes prosecution witnesses can end up being more helpful to the defense. And if this doctor can talk about these things happening before Frank Bybee even came into her life, then I think it hurts the prosecution's case because it hurts the credibility of the victim. And at the end of the day, it's going to come down to a he said, she said, unfortunately.
But the fact that you do have some of the forensics with the computer and the email, certainly for jurors that are wanting something a little harder than just he said, she said evidence, would certainly help in that sense.
Yes, I think that the fact that one of these emails came from Frank Bybee's IP address and not her own is pretty damning, because if a juror already believes that, he's willing to do something like this, again, like you said, they just need some more evidence. And it really comes down to the jurors in this case. And one thing that's interesting to me is the fact that this is a case in Florida where jurors tend to be, your jury pool reflects the overall population, and it tends to be an older community, a more elderly community. And if not older people, at least people who take care of more elderly people. And, that is a plus for the prosecution just because of, the victim's age.
Yeah, and I think Kathy, our producer, was able to get this email, which I think is really some bombshell evidence that we found out about this morning. Here it is. The subject was to Dr. Brad Lerner, killing myself tonight. I'm going to kill myself tonight, some expletives, and then thanks for your help, Marcia Soul. But again, when the doctor was testifying just a few minutes ago, he was saying that the last time that the victim threatened suicide, she did it via phone call, and she called him on the phone. He also said that she wasn't one to usually use swear words, and you can see in that email, obviously, she's swearing. So interesting. Does it make a difference?
I'm sure there's going to be people who take the stand who say, I've never heard her use a curse word in her life. She's a sweet old lady. She would never do that. Phone call versus email doesn't really matter to me. But again, the timeline does hurt, because if this doctor can say that she tried to kill herself before October 2016, before the defendant even came into her life, then it kind of hurts the prosecution's theory that Frank Bybee drummed this up. But then again, at the same time, they can spin it as he knew this about her, the defendant knew this about her, so he took advantage of the situation. He had all of these little pieces, so he just had to take it one step further, and it would be completely believable, and he could get away with this crime.
And she did try to commit suicide, according to testimony, prior to this, and that was actually the reason that Deputy Bybee was initially called and met her. So it was a so-called Baker Act, which is the Florida law that allows for someone who's suffering from a mental illness or threatening to kill themselves to be committed into a hospital. That's how the deputy initially met her. So, clearly I can see how there's some issues with this woman's perhaps mindset and her credibility, but it does seem that we do have some hard evidence linking the two, like the IP address that we were just speaking about.
And that's why I think in certain cases you have to watch how it's charged. You know, he's facing a multitude of charges, and sometimes when there's so many, the jury will pick and choose. So, you know, when they can't fully believe something beyond a reasonable doubt, they will, you know, I could see a situation where he's convicted of exploitation, of all of the theft charges, the forgery charge, because those are a little bit, they're more simple. You know, the theft charges, you just follow the money trail, basically, and all she has to do is get on the stand and say, I didn't give him permission, which she already did. So, you know, that's one and done. But some of these more serious charges, including the one where he could face a life sentence, the attempted murder charge, you know, the burglary charge, the battery charge, those, I think, become more of a question when you're starting to doubt the credibility of the victim herself.
It will certainly be interesting. So what I'm going to do, I'm going to keep Mari on. Hopefully you'll stick with us because we have some other topics we want to discuss, including O.J. Simpson's pending release from prison. Believe it or not, it's coming up most likely in just days. So Mari will tell us what to expect with that. In the meantime, I want to review some of the testimony from that forensic computer scientist that we were talking about from earlier today. Let's go to clip number 17 of the computer forensic detective to give us a flavor of what he found, which might be a little boring, the testimony, but it was really important to this case.
It has Ms. Soul's email address coming from her AOL account. Does that mean she sent it?
Only if she was at that address when it was sent.
Okay. Can someone use someone else's AOL account and send an email?
Sure. All you would need is the username and password.
So someone would have to sign in as Marsha Soul.
Yes.
With their objection leading. With their username and password. Right?
Correct.
To have it appear that it comes from the soul. Is that fair?
Yes, that's fair.
Okay. So they can fake an email by having their.
Mr. Jackman, don't push my overrule too far, please.
All right. Is it possible for someone to fabricate or fake an email that it appears to come from someone?
Yes.
How do they do that? What information would that person need?
A username and password would be one.
That's it?
That's it.
But they can't fake the sender's IP address. Is that fair?
That is fair.
I'm going to show you State's Exhibit 16B. And I'm going to label it 16 double. Use 16B and double. Did you recognize that?
Yes, 16B, I recognize.
And 16 double.
Yes, sir.
What is 16 double?
16 double D is the email header along with the email content for 16B. Yes.
Throughout this time, the state will limit out as 16B and 16B. Okay.
No objection having been heard, 16B and double B are admitted and may be published at your discretion.
Showing you 16B. What is 16B?
16B is an email. Again, this information, it appears that this email is from Ms. Soul. The date is December 28, 2016, 11:49:53 Eastern Standard Time, which is where we're at. It is to dombro@comcast.net, which is Marianne Dombro, and the subject is killing myself tonight.
Okay. Now, can you source where that email came from?
Not from this email here.
Okay, what information, again, do you need to source where that email originated from?
The email header information.
Okay. Showing you 16 double B. Can you source where this email killing myself tonight originated?
Okay. Again, let's verify that it is the correct email.
Well, why don't you stand up?
Oh, I'm sorry. That's right. So let's verify that it is the correct email, because that's the most important thing. So the date is December 28, 2016. 23 is 11:49:53. This means Eastern Standard Time. It's from Ms. Soul. It's to Ms. Dombro. The subject is killing myself tonight. Okay. We have the right email. I also know this is the right email because I physically went to Ms. Dombro's house and logged into her account and obtained this. So
That's how you got the header. You actually retrieved it physically from her computer.
Correct. So again, X originating IP. Let's look at that. It's 47.197.67.65. And then we go to the bottom of the relays. And we check the first relay, which this mail server had made the handshake with 47.197.67.65. So that is the IP address that this email was sent from.
Okay. Now, going back, are you able to determine the physical location where that email was sent from?
Yes.
Okay. And again, how do you do that?
Through the subpoena results of the business records from Frontier.
Okay. And is it the same IP address that is the defendant's residence?
Again, 47.197.67.65. 5748 43rd Court, East Bradenton, Florida.
Is there any doubt that the email to Marianne Dombro states as 16B titled "Killing Myself Tonight" was sent from the defendant's modem at his residence?
No,
No doubt.
no doubt. Could you please put the other exhibit back? I want to just say one thing that's really important that we also have to determine. I explained to you guys about the dates and the dynamic IP addresses. So this, when we ask for the IP address and the subscriber, this is the date range and time range to which this residence and the modem at this residence was assigned this IP address. We have to make sure that the emails that were sent are between these two dates. Otherwise, that dynamic IP should have been assigned to someone else. But this business record shows that this IP address was assigned to this address between these dates.
So you talked about faking an email and saying that all you need is a username and password to have it appear to come from someone else.
That's one of the ways.
Okay.
Yes.
But the recipient, unless they go to the header information and do what you did, tracking an IP address, would have no idea that it came from someone else.
Correct.
I'm going to show you, well, first let me show counsel. I'm going to show you two documents, 16A and 16AA. And ask if you recognize them.
I do.
What are 16A and 16AA?
16A is an email that was received by Philomena Pereira, and 16AA is the email header information for that email.
Were both those documents obtained by the sheriff's office?
Yes,
And did you do a forensic analysis on those documents?
I did.
Around this time, you say the rule of evidence states that it's 16A and 16AA. No objection.
Objection having been heard, 16A and 16AA are admitted.
And welcome back, everybody, to the Law News Network. I'm your host this morning, or I should say this afternoon, this Friday, Rachel Stockman, and we were just listening to some testimony from the Frank Bybee attempted murder trial that's happening right now in Florida. You can see right next to me is our guest, Mari Henderson. She's an attorney out in California. We were just talking about some of this testimony from the computer expert. What do you make of it? Do you think it was pivotal to this case?
Yeah, I think the fact that these emails can be traced back to the defendant's IP address is really damning for the defense, because, you know, how do they come back from that? All they can say is, well, you can only prove where it was sent, but you can't prove who wrote it. But I mean, you know, the fact that it was sent from where he lives gets you 95% of the way there. And
part of the questioning by the defense was, well, perhaps it could have been a saved email that she somehow had in her in her outbox that she was going to send, so she had written it. And it's like, I'm hearing these possible scenarios and I'm rolling my eyes. I've got to imagine the jurors are doing the same.
I'm sure they are. When I was listening to that testimony, the only thing I picked up on was when they were asking about drafts and outboxes. The person on the stand, the forensic expert, talked about Candy Crush, made a reference to Candy Crush, and I was like, that's what's going to stick out in the jurors' minds this morning from from that expert. You know, sometimes with forensic experts and things, if you get too into the weeds, the jurors get lost and they don't care.
Well, yeah, and that's the thing, too, especially when it's really important testimony, right, which proves a part of the case. If you lose the jurors during those moments and you go on too long with some of these witnesses, it actually hurts your case, because they need to be paying attention to some of this.
You know, luckily this is a pretty bizarre, fascinating case, so I'm pretty sure the jurors have been on the edges of their seats, you know, all 3 days of testimony, just because of the really bizarre nature of this alleged crime, of the relationship between the two, and how, you know, everything developed.
So, Mari, I wanted to talk to you a little bit because I know you're writing a piece for LawNewz.com on the OJ pending release. So, at last check, we covered here on the Law News Network his parole hearing, which millions of people watched. This was the parole for his 2008 conviction for robbery. And the parole board made the decision that after serving his time in prison that he was going to be released on parole. The earliest date that he could be released was October 1st, which of course is just around the corner. Mari, what do you know about his release? Could we see him out by Monday?
Yes, so October 1st is a Sunday, so people from the prison have already said we don't do releases on Sundays, so the earliest it could happen is this Monday, October 2nd, and he will be transferred from the prison he's at outside of Reno, Nevada, over to a prison closer to Las Vegas, and then he will be released. And one of the prison officials already said there's not going to be any media or any cameras, that she herself will take a video that will be released to the media. And I'm sure just as the parole hearing was called the parole hearing of the century, this will be plastered all over.
If that's possible to have a parole meeting of the century, but yes, it did happen. So one of the interesting things, OJ's attorney has kind of been making the media rounds and talking about some of the first things that OJ is going to do once he's released. He's gonna apparently get a new iPhone. That's on his list, but it's not clear, Mari, do we know where he's planning to live? I'd imagine probably not Nevada, but I don't know.
O.J. Simpson himself in his parole hearing made a reference to, I could stick around Nevada, but you guys probably don't want me. All indications are pointing to him moving back to Florida. That's where his 2 children with Nicole Brown live, and oftentimes when a parole board is deciding whether or not to allow the former convict to move out of state, one of the considerations is where they have family. So, you know, he'll probably move to Florida for that reason, and more importantly, because we cannot forget that he still has a $33 million verdict against him in a civil suit that the Goldmans won, you know, nearly 2 decades ago, or 2 decades ago. And in Florida, when you purchase a home, that they can't take that home away from you and then use the money collected from that towards the civil settlement. So that's one of the reasons he even moved to Florida in the first place after that civil trial.
One of the interesting things too, Mari, and maybe you know a little bit about this, is that actually he now owes more than the original judgment because of the interest. And we had the attorney, OJ's attorney, excuse me, not OJ's attorney, the estate attorney that's trying to collect this money on behalf of the Goldmans on the Law News Network, talking about the minute OJ gets out of prison and tries to capitalize on his release, maybe write a book or do anything like that, people are going to be knocking on his door trying to get that money. So I assume he's going to be taking that into account as well.
That estate lawyer is going to be watching O.J. Simpson's every move. You know, the first book he wrote, If I Did It, the Goldman family successfully was able to secure any of the royalties from that book, so O.J. Simpson really didn't see any profits from that. That went right towards the settlement. But still, Ron Goldman's sister has said that O.J. Simpson has barely made a dent in the settlement. 1% of it has been paid. The lawyer said it was in the 6 digits. I mean, not a lot of money has been paid towards this settlement. And of course, with the renewed, you know, attention on O.J. Simpson because of the 2 television series last year, you know, the second he gets released, the media will come knocking at his door. Diane Sawyer, Katie Couric, who's going to get the first interview, and what that price tag will be.
Oh, so you think that the media is going to pay for him? I thought journalists aren't supposed to pay for interviews, Mari.
It's, you know, we'll see what happens. You know, the media, the interview may not be paid for, but any of the deals that come after that or as a result of that interview, you know, I think that he's definitely going to be looking for a payout, but then at the same time, these lawyers for the Goldmans are going to be, knocking on his door and trying to figure out how they can collect that money.
Well, it's certainly interesting. We're going to be following, as we have, this very closely here on the LawNewz Network and report to you any new details when we find out that he's been released. As Mari mentioned, they aren't actually going to allow cameras. I reached out to the public information officer a couple of days ago asking whether we would be able to stream his release from prison. And it appears that they're not letting any cameras because it was such a zoo during the parole. And they're actually going to have someone from the prison film his release and then post it up on their Facebook page. Kind of interesting. I can certainly understand why the prison's doing that. It was a complete nightmare with all the media there during the parole board hearing. But I guarantee you that's not going to stop many media outlets and paparazzi from camping out at that prison in Nevada until he is released. It's certainly going to be interesting to see if we hear from him, what he's going to say. Mari, did you watch any of the parole hearing? Because a lot of us were a bit taken back by his statements that he made during that board hearing, considering he wanted to get released at that time.
Yeah, I mean, he's kind of delusional, in my opinion. I mean, he was showing remorse for, the crime that he is in prison for, but the elephant in the room is the crime that he never went to prison for.
Exactly. And the interesting thing, too, is usually during parole board hearings, it's a time to be remorseful and to say how you've served your time and how you've been a model citizen. And at times during that hearing, he was really trying to relitigate the case and maintain his somewhat innocence as well in that case. So it's certainly going to be interesting to see what happens when he's released. I want to thank you, Mari, for joining us here on the LawNewz Network. I understand Mari and I go way back actually to college. We were in college together, and I wanted to congratulate you because I understand you are taking a new job and you're going to be a prosecutor in LA.
Yes, I will be joining the Los Angeles County District Attorney's Office. I look forward to the experience and hopefully joining you again on LawNewz.
Excellent. If you ever have any good tips of any celebrities that have been arrested, be sure, you know my email, so be sure to send them my way. We'll certainly be happy to take them.
Well, thank you so much for having me on today.
All right. Have a good day, Mari.